Hello, everyone. We'll be starting in just a moment. Hello, everyone, and welcome to our webinar. My name is Tobias Eigen, and I am Community Builder for the Global Legal Empowerment Network. I'm located near Seattle on the west coast of the United States. I will be facilitating today's webinar. It's Thursday, May 12th, and today we've come together to hear about Groundtruthing from Kanchi Kohli of the CPR Namati team in New Delhi. Questions will be handled by our moderators, Kritika Dinesh, also in New Delhi, and Michael Otto from the network team in New York. Before we get too far into today's proceedings, I have some brief housekeeping. First, I'd like you to take note that this event is being recorded, and we will share the full recording and highlights later on our website. I also want to make sure you can hear well and are able to use our webinar system. You'll see a questions pane where you can type in your questions and communicate with the moderator team, and a button for raising your hand. You can also select a button to toggle between full screen and windowed viewer, which is very handy. So why don't you go ahead and raise your hand right now to let us know that you're able to hear me, and also to confirm that you're able to raise your hand. Great, I'm seeing some hands going up. McKinley and Meenakshi, Nicholas, Priti, Rachel, Satnam, Surya, Tafadzwa, Vivek. Wonderful, wonderful. So great to see all of you here, and so great to see so many of you raising your hands. There are many who are not raising your hands yet, though, so if you could raise your hand, please. Just take another moment. Gino. So great to see all these names that I recognize from the registration and corresponding ahead of the webinar. Amy, Ananya, Bharat, Daniel. Great. Well, I think we have a pretty good list of people who've been able to raise their hands. Okay, I'm going to go ahead and lower your hands now, and I'm going to ask you another question. Can you please use the questions box to tell us where you are coming from? And we'll take a moment to let everyone type in where they're coming from. Great. Chiang Mai, Thailand, Mumbai, Canada, DC, Lamu, Kenya. Oh, I love Lamu. I used to live in Kenya, so I used to go to Lamu on a regular basis. One of my favorite places in the world. India, Delhi, WRI in DC, Pratik from Delhi, DC, Mablu in India, Lincoln, Nebraska. Live with Kanchi. There's a group of people together with Kanchi right now, who's going to be presenting in a moment. New York, Sierra Leone, Bangalore, Singapore, Belgium, South Africa, London. Great, great. Well, thank you all so much who've written your where you're coming from in the questions panel. So it looks like we're ready to get started. Many of you are not already members of the Global Legal Empowerment Network, so you may be learning about us for the first time right now. So what is the Global Legal Empowerment Network? We are a growing community of now more than 600 organizations and 3,000 individuals working to advance justice around the world. There are lawyers and community paralegals, human rights activists and grassroots organizers, health advocates and educators, researchers, journalists, and public servants. We work in local communities and we collaborate and learn from one another across regions and across disciplines. How do we do this? We connect to the internet using a mobile and email-friendly discussion platform where we discuss problems and share solutions and opportunities with one another. We also learn from one another in person at webinars like this one and in face-to-face learning exchanges, leadership courses, and other events. We share legal empowerment resources in our online library, which today has more than 800 free training materials, monitoring and evaluation tools, case management forms, academic research, and more. Last but not least, we join together to campaign on issues that affect us globally and nationally, such as the Sustainable Development Goals. So how can you join the network? Well, it's free and open to all. You just have to complete a sign-up form on our website, and you're in. I will be getting in touch with all of you after the webinar to invite you to join the network website via the network website. And I'd be happy to hear from each and every one of you to answer your questions and help you set up your accounts and start participating in community activities. So now I'm pleased at last to introduce Kanchi Kohli. She will be speaking for 25 minutes and with breaks to check that everyone is still following. Please add your questions as we move along in the questions pane. Krithika and Michael will collect your questions and make sure that we answer each and every one of them to the very best of our abilities. There will be time after the presentation for more questions and also to give the floor to participants. So let us know via the questions pane if you'd like to be unmuted and the question or topic you'd like to talk about. Kanchi Kohli works on environment, forest, and biodiversity governance in India and their interface with trade and industrialization. Her work seeks to draw empirical evidence from sites of conflict and locates it within the legal and policy processes. Kanchi's work emphasizes the need for both research and advocacy as essential to highlight aspects of regulatory design and how it influences ultimate outcomes related to livelihood and ecological security. She has individually and in teams authored several publications, papers, and popular articles. And now she is about to speak to you all. Kanchi, over to you.
Thank you, Tobias. Am I audible? Is everybody able to hear me? Tobias, are you able to hear me?
I can hear you very well, and I see people are raising their hands to let you know that they can hear you. That's great.
Thank you.
Go ahead.
Thank you for joining into this webinar, and I think upfront I'd like to acknowledge that while I'm the speaker here, much of this work is collective. The thinking behind this is, not just the EJ team, which is working with Center for Policy Research in Namati, but all the people we work with who are part of the Groundtruthing efforts who helped actually build this methodology with us. So yeah, without their backing, this presentation would be nothing. To take the presentation forward, I'd just like to highlight that we will be trying to break up this presentation in 5 parts. I'll try and lay out the background and context and speak about the context of conditional approvals and regulatory safeguards, which are really central piece to the compliance work that we do and the ground truthing work that we've been doing and we've been building towards. And then get into what is ground truthing according to our experience and the methodology, an example of a community-led ground truthing effort, and then finally end with certain challenges, because actually, while how much ever exciting it may sound, this really, when it plays out on the ground truthing when it plays out on the ground is quite a challenge. So I'll just lay out the background and context, and the background and context is also that why is it that the environment justice program, this collaborative environment justice program, really tried to work in already transformed landscapes, and with the focus on compliance? Most cases, many countries have really old projects of 30, 40, 50 years old, whether it's mining projects or power stations or industries which are where people are living around, and these are considered to be impossible or lost causes. And we also felt during our work that these might not be as charismatic as challenging new consensus and approvals. And this is not to say that that piece of work is not important, but it might not be as charismatic as challenging new consents and approvals, but it's an important area of work, and it's an important area of work where the ground truthing methodology really works well. Whereas the methodology can be used in other contexts, the ground truthing methodology has fairly worked well in these instances. We're often the responses we also get as part of the work is that this is the work done after the fact. So it's a work. It's really, you're entering the scene after an industry has come up or after the mining operations have started. It's really, what's the point coming in at that point of time, and that's the area of work. There are questions also raised about okay, if you are accepting this sort of development, are you being co-opted? And in many ways, what this work is trying to respond to is the challenge of compliance, and how is it that ground level evidence can inform better environmental decision making in other places, and as well as the same place where the ground truthing methodology is being used. So it operates in a space where the powerless, vulnerable, and hopeless citizens meet corporates and governments, which are often saturated by power and habituated to being above the law. So you are starting in a place of conflict. What are the manifestations in scenarios like this? We are talking about large-scale land conversions, water contamination and depletion, loss of habitats and species, impacts on local livelihoods and health. And these are areas, as I mentioned, are areas of open conflict, where the conflict on environment versus development really plays out strongly. And often in many of these places, there is a breakdown of rule of law. Many of you who joined in this webinar probably are aware of these situations. I'll just go through a bunch of photographs which kind of visualize these manifestations. For instance, there are rapid transformations and restrictions of access. So the first picture is of a place which was earlier a grazing ground for camels and camel herders. There are instances where non-compliance and has led to choking of rivers and degradation of forests. Toxic ash dikes, dust impacts. In fact, this is a picture of a place where the community actually said, the air is so bad and the water is so bad that we can neither cook nor make tea. So it really played out very strongly what the level of impact was. It's also talking about risky living, right next to mine overburdens. This is a picture from India, but I'm sure these are scenes which are which you can see in different parts of the world as well. Water contamination, a very clear output of many instances of non-compliance, of whether it's power stations, industries, or mining operations. And finally, often local communities with involved in nature-based livelihoods are squeezed out by neighborly expansion. So the power plant just behind this fishing harbor is just inching away in squeezing out existing homes and livelihoods in these spaces. Before I move on to the next section on conditional approvals, I just wanted to just flag and then just pause here and just check with everybody if it's been okay so far. If you could just raise your hand and let me know, and also use this opportunity if you have any questions or criticisms or responses to anything that I've said so far. Could we take about 5 seconds to do that, please?
Yes, go ahead. I'm going to lower everybody's hand. I hadn't done that before. So why don't you go ahead and raise your hands, everyone, just to confirm that you're still following along. Thank you. Amy, Aditya, Anika, Piyashri, Daljit, Demandeep, Denise, Elizabeth, Gino, Hadija. Great. So everybody can hear you fine. Please also take a moment to add your questions to the questions pane, and we're gathering them to be addressed at the end. That's great. All right. Actually, well, the names are all alphabetical, so I'm naming all the people early. Lavleen, Malcolm, Kamara. So nice to see our colleagues in Sierra Leone also participating today. And actually, Mustafa, this really is a global event. Okay. All right, go ahead. Why don't you carry on, Kanchi?
Okay. So yeah, moving on. I mean, it's not like governments and institutions, their administration or courts haven't really put out systems to address these conflicts. There are instances, there are laws, environmental laws, other land-related laws in different countries which lay out procedures through which there would be, each of these operations would need to go through a procedure of regulatory decision-making and result in conditional approvals and a set of regulatory safeguards which need to be followed. And most countries, if you just map out the kinds of regulatory protocols that need to be followed or legal systems that need to be followed, there are systems, good or bad, related to impact assessments and public hearings, conservation and management of forests, specifically on wildlife, land acquisition and rights, and pollution control and management. And each of these approvals, licenses, permissions for any of these operations more often than not, result in a set of conditions or safeguards that are given to an operator. These might not be strong enough, but they do exist. Just a few examples of the kinds of conditions that are laid out. For instance, this one is from an environmental approval in India, which talks about, for instance, fishermen vessels of local communities are just not to be interfered with. Another one from Kenya, which with the help of our partners, Natural Justice, we got access to some of these condition letters. Basically says that all conditions, if not complied with, would be in contravention with a particular legislation. And that means it attracts provisions of that legislation for penalties and often revocation of those approvals. What this means is if you don't really comply with all the conditions and safeguards or any of the conditions and safeguards laid out as part of your approvals, action could be taken or licenses could be revoked. But it also means is that if these are actually complied with, many of the problems and the scenarios that showed out in those pictures might not actually exist. So that's where we actually enter in. The other kind of a condition that we have in front of us is basically related to coal transportation. Transportation of coal has to follow certain guidelines, protocols, which more often than not does not happen. So either they need to be, there are very clearly laid out conditions that they need to be, transportation needs to be by rail or a conveyor belt, or it needs to be done through, covered trucks, following very clear time specifications on when the transportation takes place. So these are the range of conditions that are actually laid out. If complied with, often problems of livelihood impact, of environmental impacts do not arise. So I'll just pause here again for about 5 minutes, or 5 seconds rather, and just get everybody's hands up again, if you can tell me whether this is okay. And of course, any questions of in terms of what I said, specifically, whether such safeguards do exist in various countries, to what extent.
I'm seeing many hands raised, and
Great.
We have 73 registrants in attendance today, which is quite exciting. Go ahead and take a moment, everyone, to reflect on what Kanchi has already said and ask your questions. Take a moment to ask your questions in the questions pane. Fantastic. Okay. Go ahead. I'm going to lower everyone's hands again. Go ahead, Kanchi.
Okay. So to the crux of what the subject of this webinar is, what is ground truthing? In many ways, it's as simple as being on the ground. What is there in the what is there in papers, what's there in satellite imagery, how does it actually play out on the ground? It also means bringing the distant government closer. So many instances, while the government is supposed to monitor the compliance of safeguards and conditions of licenses, they are very far away from where the impacts are actually playing out. So in many ways, it is about, through this exercise, being on the ground and bringing the distant government closer to see, smell, hear, and really sense the truth of the ground. Because all these impacts are actually have very strong manifestations which you can see, smell, hear, and actually sense and feel. And governments far away from these places are just not able to do that and are lost in paperwork. So ground truthing, very simply, is corroborating legal requirements stated in official documents with very clear observable facts at the site. And I'm emphasizing observable facts because the method actually emphasizes on how local communities, without necessarily scientific technology or expert knowledge, can corroborate what is there in the documents very clearly in relation to what is there on the ground. So the license letter might say that this pipeline should not pass through this route, and it is there. Or for that matter, you should not dump muck in that forest that I showed you the picture of, but it is being dumped there. And as a result of which it's having livelihood and ecological impacts. Ground truthing also talks about creating evidence through physical verification, using maps, photographs, and official documents, which are easily accessible, or rather, you push to get out through this method. Might not be always easily accessible, but you try and use these tools to actually create the evidence. It's always directed to a regulatory authority or an appellate mechanism or a judiciary. It is talking about long-term responses and activating these systems so that it's not just a direct negotiation between the company that is impacting and the affected communities, but is directing long-term change through a regulatory system or an appellate mechanism. It could be a one-time investigation or ongoing monitoring. So you could actually do a ground truthing right there, or do it on a regular basis in an operation, in a place. It can be used used at pre-approval evidence building or post-approval monitoring. What I mainly I'm trying to talk about here is that sometimes, as I mentioned earlier, even prior to a project really coming up, or a mine or an industry really coming up in an area, this methodology can be used. But we have effectively tried to use it in the post-approval phase, and primarily because this is a methodology least used in that phase. Mostly it results in either protest or litigation. So you're trying to use the ground truthing methodology to invoke administrative remedies through a very sound evidence building mechanism. What do you need for ground truthing? Working knowledge of laws and regulatory practice, that is a must, because whatever you collect is linked to a legal hook, and it's also linked to a regulatory practice. It is very clearly linked to the fact that there needs to be availability of official approval letters, agreements, and licenses related to a certain operation. It's all because this is talking about corroborating it on the ground and also observable facts. Access to the specific site of impact, or at least the surroundings, is critical. It also links, it's not enough to know the laws or regulations, it also links to the fact that you need to have the knowledge of the range of institutions where this evidence could be directed. So it's not enough to actually link that the EIA process is being violated, but where does the remedy actually lie? Which institution can you really take this to, closest to the site of conflict? It also emphasizes on minimum 3 sources of evidence to rule out chance, probabilities, Often in court matters, this is a critical thing. But in the ground truthing method, we talk about at least minimum 3 sources of evidence to actually triangulate the claim. Ground truthing could be at different scales. It could be done by individual or small teams, either environmental or rights-based organizations, along with key informants in a community. So you can actually use the letter and the facts on the ground and just file complaints. It could be through more of a community-led process, which I'll talk about subsequently, through a bunch of community representatives, along with external legal education and empowerment actors, researchers, lawyers, environmental organizations. Or ground truthing can be a very critical component as a methodological step in the legal empowerment approach, which the EJ CPR Namati Environment Justice Program is trying to use in its applied research and legal empowerment program in India, and now trying to share it across the world as well. So it's an essential step in the community paralegal approach as well. A 5-second pause to say if it's going okay for everybody. Please type in your questions and give us your response.
Yeah, go ahead and raise your hands, everyone, just to show a sign of life and that you're able to hear fine. Great, we're getting a lot of hands coming up. Wonderful, wonderful. Take just a few seconds to compose a question or two and add it in the question pane. And I'm going to lower your hands again, and please add your questions to the question pane. If you have a question, the hand raising, we're only using it at the moment to show a sign of life. Later on, we'll use it for other things, but for right now, it's just to make sure that people are able to hear. Okay, I'm going to lower hands. Go ahead, Kanchi, carry on. This is going very well.
Yeah. So, the fourth segment of this presentation is basically a particular case where a community-led ground truthing effort, which was a collaborative effort between Center for Policy Research, Namati, a couple of local organizations, and a local community-based organization in the western part of India. It basically involved 6 steps. Starting off, it meant that researchers, not legal practitioners, researchers who use law, local organizations, community-based organizations, as well as representatives from the community, affected community, actually sat down together to understand the approval process. What does it take to, for say a port in an area to come up, and what has been the process so far? Has it received a license? And if it's received the license, what are the licenses and the safeguard conditions that have been laid out? So understanding the approval process was the first step. Through that approval process, identifying the mandatory conditions or safeguards that need to be followed by this operation, and not following which would have resulted in the impacts. For instance, a condition of non-destruction of mangroves, or for that, the condition that I showed you earlier in terms of not restricting access for fishing, or non-destruction of sand dunes, etc. So that was the understanding the approval process, identifying the mandatory conditions and safeguards was the second step. The third is the process of actually collecting evidence and mapping out, whether it's through satellite imagery or participatory mapping, actually do evidence collection for this process. Subsequent to this, it's not enough in a community-led ground truthing process to actually link the evidence to a law or a legal violation. A critical component of this process is to discuss the remedies that need to be sought. So for instance, are you actually looking at closing down the operations, or are you looking for just remedial measures? Are those remedial measures actually possible? That discussion becomes a very important part of the ground truthing process. What is the remedies being sought? And subsequent to that is the drafting the ground truthing report. So it could mean people contributing different parts of it. Somebody actually takes responsibility of putting together the evidence, writing it up, somebody else doing the maps. So that process of drafting the ground truthing report is the next step, including the remedies that you're asking for. And finally, because understanding, as I mentioned, the institutional link was critical earlier, submitting the report to an appropriate agency. These were the 6 steps that were followed in the community-led ground truthing process. These are just some pictures in terms of how it really played out. So sitting out together and looking at the map of a special economic zone and how it shows up on a Google Earth imagery, or sitting down together and mapping out where, just at a beach, what's really happening. I think many of you will be very familiar with doing these things with other kinds of work as well. This is basically the kind of evidence that was created for one particular community-led ground truthing effort that I'm talking about. The picture on top is satellite imagery of the year 2000, which talks about the red is all mangroves, the brown is all mud flats, and by the end of it, by the end of 2011, after the port, etc., has come up, you actually see all of it destroyed. Now, the port authorities could actually say that this is fine. Once you construct a port, it's all fine. We expect this destruction. However, in this particular approval process and safeguards, it was very clear that mangroves do not need to be destroyed and fishing access needs to continue, both of which actually had been stopped because of this land use change that took place. And this was part of the ground truthing effort. This was corroborated along with pictures of mangrove destructions, blockage of access, like the kind of picture that I showed you in the very beginning, where there's a car trying to go through a walled in a walled area. So this is the kind of evidence that this process really tried to create. And subsequent to this process, in the same area, CPR and Namati have together tried to build this methodology into a community paralegal process, where if you can see the second part of this case form that is used, the action by the paralegal in this legal empowerment approach talks about evidence building and dossier creation, and which is the ground truthing method is central to this process, which has taken place subsequently. 5 seconds. Please show us your hands. Any more questions before we end with the challenges?
Okay, I'm seeing some hands coming up. 25 hands are up, so people are able to hear you just fine. Go ahead, everyone, and add your questions to the question pane. And we're reaching the end of the presentation now, so soon you'll have an opportunity to hear the answers to your questions. So go ahead and take a moment to compose a question or two. Thanks so much. Okay, I'm going to lower your hands. Kanchi, carry on, please.
So it's all not very sweet and happy, even if not all problems can be solved with ground truthing. There are areas and friends and partners internationally have told us that it's not so simple. Maybe in countries like India, you can assume that certain documents are available. It's not the case everywhere. Even here, not all agencies are cooperative. There are a whole bunch of challenges of actually really using the method of ground truthing, and which is true. But this is our innovation is in terms of how do you actually overcome some of these challenges. The first are the restrictions on access to information. The very information that you're relying on, license letters, agreements, safeguard information, laws, that is not easily available. There are no public tools through which you can access these information. So it's like right to information laws or access to government agencies. There are those real restrictions that which do exist. Even if this information is available or is made available through a process of negotiation and dialogue, these do not actually include adequate safeguards or license conditions. So even in the places that we've worked, we often might actually get access to these documents, but the conditions are not strong enough that you can actually ground truth, which of course is an important step in the moment you are not able to ground truth, or you can find evidence in terms of non-compliance, becomes an important process through which you go back to the government and say, unless and until the conditions and safeguards are are strong enough, you're not going to be able to address the impacts that are played out. Creating legally admissible evidence requires creativity. It's not always easy to actually get those at least three sets of information together. There is the kinds of cases that we've been involved in, whether it is tracking a pipeline or actually, just going and talking to people, all kinds of, or taking the help of another government department to actually back up the claim, requires a lot of creativity in terms of creating that evidence which is observable and linking up to the document itself. There are places where there are clear conflicts with government. There's a trust breakdown, and very often affected communities are also would not be interested in talking to governments, and governments might not be interested in talking to communities. But then the fact is, how do you actually address some of these gaps and make these processes, processes where I mentioned earlier that you actually bring the government close to the place. You actually bring them to the ground. It's pretty far away and sitting smug somewhere. The final thing is here that the remedy substantially also hinges on institutional response. You can actually build this evidence, you can build a relationship, but it hinges on an institutional response. And if the institutions and the government agencies don't respond, then the conflict might not be resolved, or you might not get the adequate remedy. Our experience has been that consistently going back to the government, speaking to the government, giving very solid, grounded evidence pushes a response, but this might not happen everywhere, and this remains a challenge. Justice finally could be a really long way off, but methods like ground truthing could be one way of walking with us while we are going towards that long way off. The two websites below will give you far more information on this methodology. Very soon we'll try and upload a note on this methodology and also try and share it with all of you. Thank you for listening, and we are happy to take your questions.
That's great. Thank you so much, Kanchi. Why don't you just leave your screen where it is? And I think it's a kind of a sobering image. Thank you so much for your great presentation. I wonder where to begin. Let's see. So we had many questions, and one of them I can respond to, which is whether the presentation will be openly available after the webinar, asked by Anika. And the answer to that is yes. We're recording the webinar now, and we're going to be posting it on our website. And so the answer to that is yes. So as soon as the webinar ends, I'll put the webinar recording up, and I'll email out to everyone the link, everyone who registered. Kritika, would you like to take the floor to address some of these questions and to communicate them to Kanchi so she can answer them?
Yeah, thank you, Tobias. The first question is from Daljit Singh. He asks how to ensure that the agency doing the ground truthing is seen as objective and unbiased. How important is that?
This is definitely very critical in especially areas where there is a trust breakdown, where affected communities don't also see an eye to eye. There is also litigation that is just opportunistic litigation that takes place. However, there are methods by which you could ensure that the ground truthing is objective, especially if it's a group that comes together and it's very clearly laid out upfront what we are trying to do through this process. We are not trying to get short-term kind of remedies or responses. We are looking at a long haul. We're looking at long-term remedies through this process. I definitely agree that this is an important thing to take care of, and but one of the things that we try and do in this, as I mentioned, was the evidence collection definitely talks about at least 3 pieces of evidence, and that triangulation method ensures that this is not just an impulsive sort of response to something that is happening. It is very clearly building that evidence. And a lot of people who are not interested in that long and detailed process might not even continue. So if you're looking for that, that's one way we've tried to address in some of the cases. And we've had cases where people who are not interested in going through with it have just said, okay, we won't.
Thank you, Kanchi. The next question is from Matthew John. He says, ground truthing seems a method to get a measure of real costs. What if the costs are just too high? Do you have examples where projects have been closed by a ground truthing exercise?
Certainly not big ticket projects. We've still not had that that kind of experience. In fact, the community-led ground truthing process, the slides that I showed you of the example, actually resulted in the government condoning the violations after accepting all of them, because it was not prudent to shut down a very an activity. However, there are instances where smaller projects are experienced, especially through the CPR Namati EJ case level work, whether it's sand mining or industrial pollution, plugging a pipeline. Those kinds of things have definitely succeeded.
Thank you. Next question is from Mansi Verma. She says, these environmental clearances, while the documents may be available in public, there may not be enough awareness among the affected people for them to be able to bring up these issues in absence of ground truthing exercise undertaken by a third party. Does ground truthing bring out such gaps also, and how can these be overcome?
Yeah, so I think, as I mentioned, in the 6-step process, the first step is really understanding the legal process and understanding which are the institutions responsible for monitoring. So it is pretty much in the heart of the ground truthing process that the legal awareness of both the laws and the regulatory processes and where the remedy actually lies is pretty much part of it. So that's why we're talking about linking it to legal empowerment. It's not enough to just solve the problem. It's important to be legally aware so that you can help other people solve the problem.
The next question is from Elizabeth Moses. Can you speak of the impact of lack of political will around the enforcement or compliance? She's also interested in connecting National Ministry Regulatory Authority versus local office. And how can we prioritize which regulatory authority to target?
Political will is, I'm not sure ground truthing can solve it. It can definitely appeal to political will when you're able to show strong evidence of impacts on livelihoods and people who are affected themselves and who are part of the the voter base of the political constituency. Actually bring it to that person. It might impact political will, but it's definitely not. It is only one piece of the big puzzle. The connecting the National Ministry Regulatory Authority versus local office, in almost all our cases we try and start local at the office closest to the site of impact, and only if you are not able to get a response there, then it goes to what we in India, of course, it's state level, but it could be a province level. At the national level, the least amount of the processes actually approach the least amount of instances which are taken to the national level, unless especially in the legal empowerment program.
The next question is from Nakul Heble. My question is about the scale, but on the side of the project is being studied. So the question is, how effective can ground truthing be in monitoring small-scale industries and their levels of compliance?
There are many cases that we have as part of the Legal Empowerment and Applied Research Program, which are really small scale. They could be small scale in an industrial area where legal safeguards and compliances apply to the entire industrial area, or it could be small scale at the community level. Often, where there have been instances like really unregulated sectors like sand mining or quarrying, where there is local participation in that activity. it gets difficult to do ground truthing because one of the bases of this ground truthing process is that there needs to be a need felt for it from the affected community. We don't just, especially as part of the community-led effort and the legal empowerment process, we don't try and go anywhere where there is not a community or a part of the community that is affected and wants a remedy. However, ground truthing can be a very effective tool, even as I mentioned, at the scale. If you're an individual along with key informers want to go and do it, it's very possible because almost every process requires some bit of licensing. It might not be in an environmental law. It could be a mines and geology law. It could be somewhere else. There's definitely some paper that the person needs to have to start operations.
The next question is from Arpit Srivastav. Don't you think that the regulatory or impact assessment process is tedious in nature, owing to which setups try to avoid such a process and do pollute the environment? Do suggest some measures.
I thought ground truthing, it could be one measure, but I agree with you. It's long, tedious. It hinges a lot on the law actually really working for the people. That's really a bigger, larger problem, which I think pieces of work like this are really trying to address. It is like really trying to appeal to regulatory authorities that you need to include things like third-party monitoring of affected communities to make it far more effective and not long and tedious.
The next question is from Sihari Dukipati. His question is, where there aren't adequate protections, can ground truthing exercise help? He also has another question. When the clearance is conditional, such as in coal transport, is it more challenging to ensure enforcement? And also one more question, how is authenticity of evidence connected established in absence of official data?
Where there aren't enough adequate protections, such as recognizing. So I think this is what the ground truthing is trying to tell you is that if you're, as I mentioned, if this remains a challenge, the way the condition of the safeguard is framed really helps a lot in doing the ground truthing process. If it's vague, if it's many conditions into one, it often does not help that much. However, what you could really point out is that we could not do ground truthing, we could not do monitoring well because it's vaguely drafted, because it's not strong enough. And that becomes an important policy input to go back and say that you need to really ensure better safeguard, better frame safeguards, so that they could be, ground truthing can be done by affected people or anybody else who's interested. What is the other one? The clearances conditions such as in the coal transport, is it more challenging? It is definitely, but there are, for instance, one of our main cases in the state of Gujarat is where we're working is of the coal handling guidelines, and I think Bharat Patel is on this call, and he's the one who brought this to the team, and which is where they very clearly set out guidelines for coal transportation, both in terms of coal handling in a particular area, in an industry or a port, and as well as its transportation. And how so basically it is definitely challenging, but if there is that legal empowerment and legal awareness throughout the route where the transportation is taking place, it's a big goal, but it's difficult but not impossible. And the third one,
authenticity of evidence.
So yeah, that's where, so authenticity of where official data is not available, as I mentioned, that is definitely a challenge. But you often get some piece of paper, either through a it might not be an environmental lease agreement, etc. It could be memorandum of understanding or something like that. That helps. If that is not available at all, then photographs, maps, testimonies, they could become an important piece to say we are bringing this so that you could actually share that official data with us or corroborate it with that official data. That's one way to do it.
The next question is from Divya Narain. Have there been any cases where the ground truthing process has been followed by bringing the corporate or the investors on board?
So So far, there have been no specific instances where the ground truthing effort has really brought the corporate or the investors on board. That has also been an important strategic decisions, because we are talking about pooling together all these instances where the ground truthing and evidence and problem solving really takes place to appeal to a better regulatory system, so that this is not a one-off response appealing to the sensibilities of a good or a bad corporate, but is affecting change and affecting a strong legal compliance and monitoring mechanism in a place.
The next question is from Nayana Uday Shankar. When the remedies or actions to be taken are discussed, who is it discussed with? The whole affected community or the paralegals? How would you handle differences in opinion about what action would be best suited?
Yeah, so as I mentioned, this is definitely not an exercise where all people in a community are coming together and there is agreement. It's a clear understanding from the very beginning that it could be paralegals along with a section of the affected people who are seeking remedy, who seeking a certain kind of remedy. Precautions are taken that a remedy that is being sought does not actually result in an impact on another part of the community. So, for instance, in a particular area where there is fishing community affected by salt operations, the remedy should not necessarily result in getting all the laborers working on those salt farms out. So that is very clearly discussed as part of these processes. It does not necessarily mean that everybody who does not see eye to eye in the community is sitting together and coming to a conclusion, but precautions are definitely taken.
The next question is from Surya Sethi. Ground truthing is based on the premise that the institutional framework that is supposed to protect the local environment and social impacts is either failed or is non-existent. Her question is, has ground truthing ever shown that all efforts were made to improve and protect the local environment and stakeholders?
So it actually doesn't really necessarily assume that it's failed or non-existent. It could just be that distance in terms of the distance of the regulatory agency and the affected people has not really been bridged. And what is the other part? Has the ground truthing ever shown that all efforts were made to improve the process
and protect the local environment?
I think in many of our cases where ground truthing is part of one of the legal empowerment, one of the components of the legal empowerment process, is almost all cases the efforts are showing that the efforts have been made. The very fact that the regulatory agency is responding more often, efforts have been made to improve and protect the local environment. So I think in many ways it's activating a system that might be, a lot of people assume is non-existent, but it does exist. It just needs to be brought closer.
The next question is from Sahil Shashidharan. How does it impact the locals and does it lead to conflicts? Also, does oral evidence get included in this framework of ground truthing, since the end result is a legal and administrative process?
Oral evidence is definitely not one of the most substantial pieces of evidence that is used in this process. So it is mostly it's mostly documented evidence, and all of that is legally admissible in a court system. What is the other part of the question? It does lead to conflicts. I mean, for instance, there are instances where there could be local interests in a particular operation. It does lead to conflicts, both for paralegals and for or the part of the community that is raising the. I mean, it's without saying it does lead to conflicts.
Should we pause now, or should we continue with the questions?
Would you like to gather more questions, or how?
We have so many questions, and what I would like to propose is that let's see. So we will definitely address all the questions after the webinar concludes, and we'll post them on our discussion platform. And so we'll link to them from the email that we'll send out to you. And I also would like to propose that if you'd be amenable, that perhaps I could wrap up the formal part of the webinar now, and then we can continue to address some more, and we can also give the floor to some participants. What do you guys think, Kanchi and Kritika? Is that a good idea? Can we do it that way?
That would be great.
Good. All right, so let me go ahead and wrap up the formal part of the webinar, which will allow those of you to leave who need to move along and continue your day, go home from the office or start your day, depending on where you are in the world. So I'd like to thank everyone for joining us, and I'm really impressed by these excellent questions and the points raised. This is really a terrific group of people. I'd like to thank Kritika and Michael for fielding the questions. It's been a little hectic, as Michael said, to try to consolidate all the questions because there's been so many of them, which is just terrific. And of course, not least, I'd like to thank you, Kanchi, for your informative presentation. We've learned a lot today about ground truthing, and it's been a real pleasure to listen to you and to get this important update about this important work. So as I said at the start, the Global Legal Empowerment Network is open to all, and membership is free. Please sign up as soon as you can so we can start learning from you and introduce you to our community for sharing and collaboration. It would be wonderful to extend the wonderful sharing that's happening here in this webinar into other network activities, a discussion platform, resource library. If you are already a member and you haven't logged in for a while, please take this opportunity to rejoin us and let us know what you're working on, the challenges you're facing, and potential opportunities you know about for collaborating with fellow practitioners in the network. And as I said before, I'll be in touch by email with a reminder invitation and also to share the link to the full recording of today's proceedings. So let's keep the conversation going. On that note, I give permission to everyone who needs to take off to do so, and those that want to stay on to discuss a bit longer, let's go ahead and do that. Kritika, let me turn the floor back over to you, and maybe you can let me know if there's anyone in particular that you'd like to offer the floor, or if we should, how you'd like to proceed with the questions.
We could maybe unmute one of the attendees and let them ask the question. I think Nakul Heble wanted to speak.
Great. So let me find Nakul Heble here. Nakul Heble, you're now unmuted. You have the floor. Nakul, can you hear us? We're not hearing you.
Or if there's anybody else, they can raise their hand and ask the question.
Hi, Kashi, can you hear me?
Yes. Yes, go ahead.
Yeah, so my question was on legal admissibility. So this is, so you start with the position that the state is either unable or willing but doesn't have enough resources to do monitoring at the most basic level. But there might be instances where you go ahead, do the ground truthing, collect at least three evidence for triangulation, while at the same time the regulator involved in this process does their part of monitoring as well. And have you come across any instances where the evidence you collected and the evidence that the monitoring or the enforcement agency collected has differed? And has that made any difference to the project?
Yeah, I think when we did this study on monitoring and compliance back in 2009, the difference in terms of ground level evidence and of sometimes what is said in government monitoring reports does come up. Often in the government monitoring reports, there is instances of non-compliance recorded, whereas on the ground you actually see that there is definitely non-compliance. In fact, sometimes the government document says, as per the project authorities, compliance report monitoring is compliance is taking place. So that's the monitoring report. It hasn't really gone corroborated the facts on the ground. So that difference does arise, but very often the difference also does not arise because one piece of evidence that the people involved in ground truthing use is often an older show cause notice issued by the same authority to go back to the regulatory authority to say, you've issued a show cause notice. We are adding on 2 or 3 other pieces of evidence to add on to let you know that the non-compliance is continuing. So it's not enough to take just issue a show cause notice and agree with the response that you receive. However, steps need to be taken to really remedy the situation. Otherwise, for 20 years, the fish in the Kolak River will continue to die.
Right. Okay, thank you so much.
Thank you, Kanchi. I think next Surya Sethi wanted to say something.
Yeah, so if you can hear me.
Yes, we can hear you.
Yeah, Kanchi, I think the point I was trying to make when I asked you the question was that inherently I see this whole thing to be further source of conflict, because the very idea of ground truthing is to go and find out whether what the regulatory agencies are reporting is right or not right, or whether they are doing their job or not doing their job, or even if, as you say, the regulatory agencies are not able to actually reach out to the ground level like you might be able to do, or the people doing the ground truthing might be able to do. So the point I was trying to make is that rather than making this a situation of conflict, can you turn it around and say that, look, or will the regulatory agencies even allow you to turn it around to say that, look, we are here to help you to see whether the project conditions are being met or not being met, and collect evidence on your behalf. Then you take away the conflict and you take on a supportive role. And then maybe there'll be greater success in actually making a difference on the ground level, because then you are essentially extending their ability to monitor and enforce.
Yeah, see, I think the process that we are actually undertaking is exactly to address the problem that you're raising. That most often than not, it has been adversarial. You actually either take on the project or you take on the government that they're not performing. The idea is to appeal to the regulatory functions to say, we are doing our part. If you could also come closer and do your part, can we actually together affect compliance and ensure there are safeguards there? In fact, in many of the cases where the ground truthing has been part of the paralegal approach, this has been the partnership has been very central. Has been a very central piece of the whole process.
It's not our part and their part. It is the same part. Ultimately the idea is the same, and the regulatory agency and the institution was created to protect the environment, protect the stakeholders, do the right things. So if ground truthing takes on a view that, look, we are simply trying to help you do your job better, and then maybe these adversarial issues fall away. I don't know. I'm just asking because I find that, from actual experience, I can tell you that there'll always be tension. You can give it a view that this is a third-party independent assessment, but there will always be that kind of tension there.
But it just could be a productive tension so that we could actually have effective part of this monitoring process, and it becomes far more collaborative from both sides.
That's
Okay, I think I'd like to move on to another questioner. There are many people that have questions, so we can go ahead and do that. Let's see. Sanjeet, would you like to have the floor?
Hello.
Sanjeet, I've unmuted you.
Yeah, I have just a small question regarding this. The ma'am told that there are three sources of evidence. They should be there in the ground truthing. So what could be probably these three sources which we could like ascertain while taking on the field work, or and also I'll also add up that while considering the conditions of the environmental clearance in India, there are a lot of lot of conditions related to the transportation of coal. But since we have filed a lot of litigation before the Green Tribunal, most of the conditions regarding this transportation of coal were not being followed. So how to insert some like a strictness in these conditions, that at least this the transportation of coal and handling should be very much effectively handled by the project proponent, so in order to lessen the pollution, so at least these basic things do not come into our way, uh, and do not pollute, aggravate the situation to the environment. Yeah.
Yeah, there are two parts to your question. First is about what could those three pieces of evidence be. In our experience, what we've tried to do is get very clear photographs, maps. Very often, we also find there has been some sort of show cause notice or the other that has been issued. There could be a media report that has been a pipeline leak or a impact of access or anything like that. There could be something like that. There could be a complaint that has been filed by an affected community that could actually corroborate the photograph and the map. Those are the kinds of pieces of evidence that we've tried to create over a period of time to actually go back to the regulatory authority and say this is part of the process of monitoring. The other part of coal transportation, this is actually in many of the cases that we've been trying to do research on and also trying to resolve through the administrative route. As I mentioned earlier, one of our colleagues actually has used very effectively the coal handling guidelines of Gujarat. And in fact, even though there are guidelines, because this guideline actually has been a flagship guideline of the government, they are very keen in actually ensuring compliance with it. Similar guidelines, in fact, stronger such guidelines, along with the approval process, if they exist, they become very important, important partners in ensuring compliance. So, I mean, as in fact for us, this is one of our important policy asks. That how can we actually, not just coal, but for other instances also gets similar, in knowing very well that there could be challenges in even implementing those guidelines.
I just want to add one more line into this. That is how to tackle the situation where the project proponent, while preparing the environment impact assessment report, the EI report, has stated false baseline monitoring data, and the data which has been collected by the proponent has been stated haphazardly in the EI report. So how do we corroborate that? Because since we are talking about ground reality, ground truthing, then we need to get these data also analyzed from some other agency. So if that agency does not concur with our views, or how to get these data being analyzed by ourselves, using it for the litigation.
See, again, as I said, this process is talking about very clear, observable facts, not talking about getting an expert agency to back up the claim. It's about also pushing the idea that people in an area are not enemies of the project or enemies of the government. They could be very willing participants in ensuring important safeguards if a project needs to come up in an area, or for that matter, the EIA has to be strengthened in its baseline you could be very important participants in that process. However, as I clearly mentioned, we feel that this process is far more effective in an area which is already transformed, where there are clear conditions that need to be corroborated. The EIA related facts can be also corroborated using the ground truthing method, which we have tried in one or two instances, but not so much. Our emphasis has been on the space of post-approval compliance.
Thank you so much, Kanchi. Thank you so much.
I think next, Lawrence had a question or a comment.
Great. I'm going to unmute you, Lawrence. Can you speak?
Yeah. Can you hear me?
Go ahead. Yes, we can. Go ahead.
Oh, okay. Thank you. First of all, thank you so much for the presentation. It was very interesting. I think I have a quick question regarding the piece of evidence collected. Beside maps and pictures, are you using video as evidence taken by first responder on the ground in the process? And if yes, what kind of challenges do you find? What kind of challenges do you have in their admissibility in court or in the process, the legal process?
Video is definitely used in a few cases, but where we can actually use photographs, it's been far more. I think for people, it's been faster to just get that just printed and submitted as evidence. Video has, in one or two instances, in fact, we faced problems in terms of the people part of the ground truthing effort have actually trespassed in a place and taken a video and tried to submit that as an evidence. So we've actually called back that piece of evidence to say we cannot use it because it means you're showing that you're also doing an illegal act. So there have been challenges in using the video, both technologically as well as how do you actually get good quality videos. But that is not to say that it could not necessarily be an important part of that triangulation.
Okay. Okay, thank you very much.
I think we'll take one last question. There is Rose. Tobias, can you unmute Rose?
Certainly, just one moment. Okay, Rose, I've unmuted you. Did you want to ask your question? I know you've had your hand raised for most of the presentation, so I hope you're able to speak. Go ahead. Rose, are you there? Looks like we've lost Rose. Are you there? You're unmuted. So the question that you had asked in the questions pane is, for Kanchi, is how have you maneuvered situations where the license does not have a condition of an issue specified in an environmental management plan? Kanchi, why don't you go ahead and try to answer that question?
Then you actually corroborate the environment management plan, not the license. The environment management plan is an equally binding legal document which you could ground truth, and not necessarily the environmental clearance condition, the license condition. This is not only linked to this process is not linked only to corroborating what is there as a safeguard in the license condition, but if the environment management plan, which is a legal document, says it could be done and it's not being done, that could be part of this this ground truthing effort. That could be corroborated, and evidence could be collected.
Thank you, Kanchi. I think we can respond to the rest of the questions through email.
Yes, great. Unfortunately, we can never have enough time to give everyone the floor who would like to have it. I do very much appreciate all the thoughtful questions, and also for everyone who stayed on to the bitter end and joined this very interesting discussion. As Kritika just said, we are going to seek to address all the questions that we received, and we will follow up directly with some of you as relevant. And I personally am also going to be writing to everyone to invite you to join the network, and we will also be posting questions to the discussion platform, so that and their answers, so we can perhaps dig a little bit deeper into some of these issues surrounding ground truthing. So I'd like to thank everyone, Kritika and Kanchi, and everyone sitting there together. Maybe I'd like to give you guys the last word, and then we will wrap up this webinar. So
thank you, and hope to see you all in ground truthing mode more in sometime in the future.
Thank you, Tobias.
You're very welcome. Thank you all so much. All right. Goodbye, everyone, and look forward to seeing you at a future webinar.